Uh, Good afternoon. Thank you very much for coming. I am Oksana Prihodko, Director of International Non-Governmental Organization of European Media Platform. I am moderator of the flash session Electronic Evidence in Time of War. Unfortunately, we Ukrainians, because of unjustified Russian aggression, are living just now in time of war and are using electronic evidence very actively. But at first, I would like to ask Georgi Yohadze, project manager of the cybercrime division of the Council of Europe, to give us more general information on electronic evidence, cybercrime convention. So, please.
Yes, thank you very much, Oksana. And again, I think we are going through a bit of a marathon here, but I would like to keep it brief, maybe to discuss 5 main points that, just for us to agree on perhaps and to understand better. Speaking on behalf of myself again, and not the Cybercrime Division or the Cybercrime Convention Committee, one question that we always have in mind when we speak about the war crimes and the cybercrime in general is actually, can cybercrimes themselves be considered as war crimes? So let's say if you imagine the pure, let's say the cyber attack on a critical infrastructure, let's say, can it be in itself considered a war crime, let's say under the related aspects of international humanitarian law? At the moment, the Cybercrime Convention Committee does not have a position on that one, because again, we keep technological neutrality, and for us, anything that is cybercrime is or anything that can be dealt with electronic evidence could be brought under the realm of the Budapest Convention. But fortunately, we have a very recent development. There was the recent paper published by the International Criminal Court on the cyber-enabled crimes under the Rome Statute. If I'm not mistaken, it's been published on the 5th of March of this year, and it actually provides very clear guidance in this regard. So one particular interesting point, but it goes forward, is saying actually pretty much clearly that the armed conflict can be also thought exclusively through the cyber means. So it does not require any more, let's say, the kinetic and the traditional attacks to be happening, but the cyber attacks may suffice to be actually leading to be considered as armed attacks, and also leading to being as war crimes. Of course, there are a few caveats there. So in order for the cyber crime to be considered as a war crime, of course, the primary object of the attack has to be the protected, let's say, asset under international humanitarian law. So it's civilian infrastructure, civilians, let's say, hospitals and others. And of course, I mean, it comes as a very good reminder that indiscriminate attacks, as we're seeing, for example, attacks of the Russian Federation and Ukraine, can be also considered in the same category. So you don't have to target civilians directly, but if your attack is indiscriminate enough, so that it includes also potentially civilian targets, or actually if there is an intent to include them even without Israelizing, then we can have the cybercrime as a war crime. When it comes to electronic evidence of war crimes, then I think we have a much clearer standard. So the Budapest Convention on Cybercrime, which applies to any crime and provides reference to electronic evidence, procedures, handling, investigative powers, prosecution, international cooperation, all the aspects of electronic evidence can be used as a basis. The biggest issue that we see sometimes when dealing with electronic evidence of war crimes in Ukraine is an issue of admissibility, and especially admissibility when it comes to open source intelligence, because just maybe to define for those who are not familiar with the concept, this is information that you find on open sources online. So it's not something that is obtained by, let's say, investigator through the course of search and seizure, or let's say production order or interception, but it's something that is available and could be actually handed over voluntarily, also from abroad. For that one, we have a more recent standard, which is provided also by the European Court of Human Rights, the Strasbourg Court, which is just across the street. In its case with Malaysia Airlines, it ruled that basically the open source intelligence can be an admissible evidence also in the context of armed conflict, and also as evidence of war crimes. But of course, the other aspects of the electronic evidence, such as, for example, integrity of evidence, audit trail, so meaning keeping chain of custody, the specialist support, sufficient knowledge and appropriate training, that are also equally important to ensure that whatever crime the investigator is investigating, including also war crimes, or the prosecutors, following with prosecutions, they also respond to this particular criteria to be considered admissible evidence as well. The third aspect that I would like to highlight is the capacities to investigate and prosecute, and there I would like to speak a little bit about a specific project that we're doing with Ukraine as a Council of Europe. This project has been funded by voluntary contributions and started since 2024, but of course as a cybercrime division and the cybercrime program office, we've been supporting Ukraine since the start of the Russian aggression against Ukraine. The main objective of that particular project is to enhance capacities of investigators, prosecutors, and forensic experts in Ukraine to deal with electronic evidence of war crimes. And that we're doing in two specific streams. So one is providing what we call generic skills, because in order to deal, let's say, with preservation of data, production orders, search and seizure, interception, and the others, you don't need to necessarily have specific skills to deal with war crimes aspects, I mean, with armed conflict situations. So these are the skills that can be used by investigators, prosecutors, forensic experts in investigation of any crime, including war crime. But of course, there is a second stream in which we do more specialized activities, for example, attacks on energy infrastructure, technical exercises, the malware network investigations in the context of armed conflict, how to apply Budapest Convention powers, how to apply international cooperation powers. So that is something that we believe is the right way to go forward in terms of really increasing capacities and capacities to process, obtain, and cooperate on electronic evidence. And last but not least, we believe that because we're talking about Ukraine, that there are a lot of opportunities that are still not used to the fullest when it comes to international cooperation and electronic evidence. For example, on the Budapest Convention, you have articles like Article 26 on spontaneous information, Article 32 on transborder access to data that can be also used to access open source intelligence, by the way. So not necessarily, let's say, the criminal justice evidence, but even intelligence could be converted into evidence if it is provided under this particular concepts. And last but not least, also the possibilities accorded by the second additional protocol to the Budapest Convention, which is a very unique instrument, also adopted recently, a couple of years ago, not yet in force, but we're working actively with Ukraine to prepare sort of implementation of this this instrument, because it takes international cooperation to the next level. So the cooperation will happen more fast. There will be more specialized networks. There will be more possibilities to obtain data directly from the service providers and from private sector in general, and so on and so forth in this regard. But overall, this is it from my side. When it comes to general introduction, this is a very important subject matter that has many aspects to it, but I would leave probably next speaker and Oksana to speak about that particular subject matter.
Thank you very much. Thank you very much, Georgi, not only for a very interesting presentation, but for your support for your project and for your help to Ukraine. And now I would like to ask Vadim Slisarchuk from Cyber Department of Security Service of Ukraine give us more special examples of Ukrainian situation. Thank you.
Hello, my name is Vadim Slisarchuk. I represent Security Service of Ukraine. What I want to tell is that war crimes are serious violations of international humanitarian law, as defined in the 1949 Geneva Conventions and their additional protocols. They include attack on civilians, the use of prohibited weapons, torture of prisoners of war, and the destruction of civilian infrastructure. In the context of Russia's aggression against Ukraine, thousands of such cases were documented. In this war, some of the most crucial pieces of evidence have been videos and photos taken by victims, witnesses, and journalists using mobile phones, as well as materials that were captured in real time by drones. A striking example includes the horrific videos from Ukrainian cities Bucha and Irpin, which quickly spread across the media and became important evidence in the International Criminal Court. Moreover, one of the most shocking examples of the use of video as evidence of war crimes is footage recorded by Russian soldiers themselves. These recordings, which reached the public, documented brutal acts of violence against civilians and the prisoners of war. They include scenes of torture and even scenes of executions of our soldiers. The collection of evidence in war is not limited to photo or video, but also involves the use of advanced technologies such as geographic information system, which helps not only identify the location of crimes, but also establish an accurate chronology of events. Also, new OSINT technologies make it possible to identify participants in crimes in order to bring them to criminal responsibility. As my colleague have mentioned, the war against Ukraine has shown that targeted cyber attack on criminal infrastructure aimed at the civilian population constitute a distinct category of war crimes. These attacks are designed to create humanitarian crisis, violate international law, and must be classified in accordance with norms of international criminal law. Also, I want to tell that it is essential to foster international cooperation in the rapid acquisition of electronic evidence. The Budapest Convention on Cybercrime and its two additional protocols are important international mechanisms for combating digital crimes, including during wartime. They provide a legal framework for the swift collection of electronic evidence from providers through procedure of mutual legal assistance and direct cooperation with IT companies. This is especially important for timely response evidence gathering and preservation under the complex conditions of war. A major challenge in the investigation of war crimes, especially in the collection and proceeding of electronic evidence, is observance of human rights, including the rights to privacy and the protection of personal data. Ukraine, as a member state of European Convention on Human Rights, ensure a balance between security and individual rights. And to conclude, the systematic documentation of war crime using electronic evidence and modern technologies forms the foundation for future justice. The Budapest Convention, satellite systems, drones, and OSINT technologies are shaping a new paradigm of investigation in the digital age. And cyber attacks on civilian infrastructure, just like physical attacks, must be classified as war crimes. Thank you.
Thank you very much, Vadim. I would like to add that there are a lot of database in Ukraine of electronic evidence which are carried by private organizations, civil society, international organizations, and so on. But on other hand, for example, if my own home is destroyed by Russian bombs, I am not allowed to make picture and to share it in social media because it can help to aggressor to correlate future attacks. And this is the problem why the world does not know a lot about crimes in Ukraine. Thank you very much for coming. Any questions? Any questions from remote moderators? No questions? If not, I see hesitation. If not, I have one question to Georgi. We are talking just recently about a tribunal in the Council of Europe. Could you please comment from this perspective?
Yeah, that puts me in a very difficult position because I cannot comment. It's a very internal, let's say, subject matter which is dealt at the very highest level, and I physically do not have access to a lot of information and materials. For me, it also came as a bit of a surprise, honestly, because I mean, I considered probably I worked with Ukraine for more than 20 years already on cybercrime, but it also still came as a surprise the news about the tribunal. But in any case, there are significant discussions, I would say, at this point to create a specific tribunal for the crime of aggression against Ukraine. And one of the areas in which we work as CyberUA project is to support the work of the tribunal, if possible, of course, I mean, and if that coordination happens, in terms of defining the crime of cyber aggression. So in which the armed aggression against the states can be also committed by the means of cyber. Of course, there are a lot of caveats there and a lot of, let's say, new areas of international public law that we have to go through, but we're already working on that particular concept with a group of experts, and that may actually come as a supportive, let's say, concept in terms of investigating and prosecuting the crime of aggression. The crime of aggression is very distinct from war crimes, because the war crimes are the crimes that are committed within, let's say, within the context of a conflict which is already happening, right? So they're use in bello, I would say, if I can use that particular Latin term. But the crime of aggression is something that, and especially the crime of cyber aggression, again, it's not an official term, is something that we do as a big intellectual exercise, let's say, within the project, but also within the cybercrime division to support the efforts of Ukraine in this regard. About the particularities of establishment, I mean, the mandate stated, etc., zero information. Even if I knew, I'm not sure if I would be allowed to speak, but I don't have that information at the moment. But I guess that information will come eventually and as the time goes.
Thank you very much. If there are no questions, please.
Thank you so much. My name is Francis. I'm from EuroDIG. I just wondered how we can deal with the issue of so of course, evidence and digital evidence is incredibly important in ensuring that perpetrators of atrocities are held to account, and also, including cyber warfare as a type, as you say, in jus in bello is also incredibly important because people rely on internet infrastructure to connect themselves to know if they need to go to work, etc. But what do we do about the proliferation of deep fakes technologies that are used in conflicts and in times of warfare? Because what I think the issue here is that then people in wider communities, maybe people who aren't engaged in the conflict but are trying to know about the conflict, don't know what to believe about conflicts because they are seeing things online on social media, and they don't know if these images, videos are actually representative of what's going on. And so I think this can lead to lots of polarization. And then I wonder what you think actually the positive side of deepfake technology and the access to it is, if we, like the previous /before on the dissemination of non-consensual images, and now also in the context of warfare, if there's so many social harms to deepfake technology, why don't we regulate it so much more so that people can't have access to it, so that these kind of harms can't come about? Thank you.
Yes, thank you. I think you raise a lot of matters that would be enough for the entire EuroDIG to fill for three full days. But I'll try to answer again just along the lines I've been answering before. So we have to really separate the matters of criminal justice and, let's say, evidence in criminal justice context from, let's say, information operations. And, for example, disinformation, the criminal disinformation, for example, and the other concepts. Because we believe that the criminal justice response sometimes is not the best tool to respond to everything. So, I mean, yesterday was a very interesting workshop conducted by colleagues from the misinformation division. So if I pronounce it, it may be wrong, but still, I think the idea is that the criminal justice response is used as a last resort. So only when you establish that the act of disinformation causes sufficient harm to be judged as criminal. So there is a sort of a level of margin of criminality that you reach through the damages of information. So that would also apply to deepfakes. I mean, in terms of each case should be judged on its merits, as it is also the principle of criminal justice, and in each and every case has to be decided whether criminal justice response is necessary, so whether it's criminal disinformation or not. About the positive uses, I honestly don't know. I mean, that is something that probably security service representatives can answer more competently, but not from perspective of myself.
I cannot tell about positive uses of deepfakes. I think it is another topic, not in this auditory. But what about deepfakes? Russia also very often uses deepfakes, but every time you see the information deepfake or information about Ukraine, about this Russian aggression, you have to do fact checking every time, because in other case you will never find the real things that has happened there. Fact checking, it's the only way. Thank you.
Thank you very much. Any other questions? Please go ahead.
I've got three actually. So to start with the first one, I wanted to ask the panelists to maybe like elaborate on the point. You mentioned the cyber attacks being war crimes in certain circumstances, but to substantiate the civilian harm of the cyber attacks as compared to kinetic attacks, where you may have immediate civilian casualties and visible harm. It may be challenging to sort of establish the civilian harm because it's often delayed in time. It would be like people with disabilities that would, or people with medical needs that wouldn't have access to services or life-saving medical assistance. And then with time, in a year, in 2 years, they die, and establishing this link between the civilian harm and the cyber attack might be very challenging. And I was wondering if Council of Europe or Ukrainian authorities were working on some methodological guidance or approaches to actually documenting this civilian harm of the cyber attacks, because as far as I understand, currently in the Ukrainian context, the data on this delayed civilian harm is not really connected, and it may be very challenging to kind of assess it. Another question is the other aspect of the digital evidence, which may be a source of valuable information about war crimes. In particular, we've seen the hacks of email accounts of Pushilin being kind of published online. And as far as I understand, there is a little bit of difficulty, although this data may provide a valuable information and valuable evidence for the cases and war crime investigations. Often these hacks are kind of carried out by NGOs like Anonymous or other groups, and national legislation sometimes might not be kind of admitting this evidence as evidence in criminal proceedings. And I think I came across a recent document by the Council of Europe on use of evidence from the conflict zones, which primarily talks about the evidence from conflict zones outside Europe. But I was wondering, because this kind of hacked data, it might be problematic from the point of view of normal data protection, but it's not like in the war scenario, like when the army in the counteroffensive liberates certain area and obtains the documents left by the enemy troops, they don't really get the search and seizure warrant to access the premises of their military headquarters that was located there. So I was wondering if any regulatory work is also going on in this field, and in terms of there is this international instrument which is recommendation, kind of the soft law instrument, the Tallinn Manual concerning application of IHL to the cyber warfare. And I was wondering if the Council of Europe finds it relevant, and if so, in what terms? Thank you.
I want to tell you about the connections of cyber attack and the criminal war crime. I will give you an example. Last year, Russia has attacked our mobile operator Kyivstar. This cyber attack causes a lot of damage to us. First of all, civilians, during this attack, there was several drone and missile attacks on big cities where people, thousands, millions of people live for now live. And this causes the impossibility to call to hospital. Also, there was no possibility to turn on the alarm systems. Just every day, every night, police has to drive on our streets with turning on the alarm systems. Also, there was no possibility to protect people from fire, from other damages that were caused by drone attacks. It is a real connection of cyber attack and war crimes. Thank you.
If I may, just to complement this, because I was just in the background also reading through the research paper that I've referred to, published by the International Criminal Court as well. So, of course, when it comes to, let's say, qualification of, let's say, specific cyber attack or cybercrime as a war crime, the damages and sort of, the severity of the damage is a criterion that could be used very often, but not to each and every attack. And not in each and every attack has to demonstrate, for example, threat to life or threat to health. So, for example, just destruction of property would be, for example, the attacks not just on hospitals, but on energy infrastructure that sort of put out the power for days, in which the population sort of is then sort of restricted by access to the basic means of, heating, hygiene, and the others. So this all also counts. So again, this is very much a job for the prosecutors who work on these cases, also to convert the specific, let's say, qualifications of cybercrime into the war crimes as well. But there is a clear connection. And again, this is not, there is no, let's say, very high standard required here. So it's no higher standard that is required, for example, for the physical attacks as well. And under the classic humanitarian law, the same principle applies as well. But I think your question also referred to if there is any sort of methodology for the claims and the others. So for that, in that regard, one thing that we probably miss to discuss is the register of damages, which is established under the Council of Europe, which operates in The Hague, not in Strasbourg. And that register is created specifically to record all claims connected to the armed conflict in terms of damages to property, to life, to health, etc. So it already started working a couple of years ago, and it's already processing quite a very large number of claims. And they have, of course, their own methodology for collecting these claims. And we had actually the visit of the members of the parliament of Ukraine and also of the prosecutors to the register to connect the concepts of cyber and also the work of the register. And I guess that more work is needed there, but at least there is an awareness of the standards and there is complementarity of what we do. And you also mentioned the Tallinn manual. We're of course aware of it, but also the Tallinn manual at the moment remains a purely academic sort of body of work. It can be pretty interesting to substantiate sometimes the positions that we're going to go forward, but for us, again, when it comes to what you talked about, let's say, admissibility of open source intelligence or any intelligence that you find on the ground, for us, the more, let's say, authoritative source of law is the jurisprudence of the European Court of Human Rights, which again, with this recent case of downing of Malaysian Airlines and specific recognition of open source intelligence, is already a great asset that we have in our arsenal. So the court went as far as saying that, in principle, any information, even collected through unverified sources, is admissible as long as the demonstrable process by which you, for example, verify it. So that as long as the Dutch investigators applied the forensic principles, the manuals, the guidelines to obtain this evidence, that evidence was considered admissible, not because it was, let's say, by the nature of it, it came from open sources and not from, let's say, the sources dictated by the criminal justice system. So there is a growing body of work that support us there, not necessarily in the Tallinn manual, but I know also that there is a work on the next iteration happening right now also in Tallinn. We are not part of it, but we're also looking forward to the next iteration.
Thank you very much. I am waiting for camera. I would like to show you mobile application of air alerts, which Vadim mentioned. And just now there is air alert in Kharkiv Oblast. And during cyber attack, this application did not work. And we have no time for more questions, and I would like to thank all speakers, remote moderators, participants for your questions, for your attention, and waiting for tribunal. Thank you very much.
We will now have a break. The next sessions will start at 2 o'clock again. Thank you.